In everyday life, we either sell or buy something. That is why learning law on sale is essential. Today, we will discuss the Book 4 of the Civil Code, Title 6, Sales. Starting off with knowing what is sale. Under Article 1458, the legal definition of sale is given. Sale is a contract, a special contract, because it involves specific legal rules and regulations beyond those applicable to general contracts. This article also states who are involved in sale, who are the contracting parties, and what are their obligations. Vendors or sellers obligate themselves to transfer the ownership, which is, by the way, the transfer of ownership is the very essence of the contract of sale in exchange for the price paid or promised. It is also their obligation to deliver a determinate date, while vendee or buyers pay a price certain in money or equivalent. The essential characteristics of the contract of sale can be remembered by the acronym COP-CDN. Firstly, the contract of sale is consensual in nature. This means that it is perfected by mere consent. The moment that the buyer and the seller agree on the object and the price, the contract is considered valid. Secondly, the contract is onerous. This means that each party must give something of value. The seller transfers ownership of the object and in return, the buyer provides payment. There is therefore an exchange of valuable consideration between the parties. Third, the contract of sale is principal. This means that it does not depend on any other contract for its validity. It is complete and effective on its own, unlike accessory contracts that rely on the existence of a principal agreement. Fourth, the contract of sale is commutative. This means that the value exchange between the parties is presumed to be equivalent. The price should generally reflect value of the object being sold, although certain exceptions may exist, such as in the case of the lottery tickets, where the outcome is uncertain. Fifth, the contract is both bilateral and reciprocal. It is bilateral because it involves two parties who are mutually bound. It is reciprocal because the obligations of one party corresponds to the obligations of the other. The seller is obligated to deliver the object, while the buyer is obligated to pay the price. And lastly, the contract of sale is nominate, meaning it is recognized and specifically named under the law. It has a defined legal identity and is governed by the specific provision in the Civil Code. A contract of sale is composed of three essential elements: consent or the meeting of the minds between the seller and the buyer, a determinate subject matter, meaning the object of the sale must be clearly identified or identifiable, and a price certain in money or its equivalent. The consideration must be fixed or ascertainable in monetary terms. Apart from this, contracts of sale may also include natural and accidental elements. Natural elements are those that are inherent in the contract and are presumed to exist unless expressly excluded by the parties. An example would be the obligation of the seller to warrant the thing sold. On the other hand, accidental elements are those that the parties may or may not include depending on their agreement, such as the place or time of the payment or the imposition ascertained in the condition. In addition to its essential characteristics, a contract of sale may also be classified as either absolute or conditional. An absolute contract of sale results in the immediate transfer of ownership upon the delivery of the object. In contrast, a conditional contract of sale involves a specific condition that must first be fulfilled before the ownership is transferred. For example, a buyer may agree to purchase a property on the condition that the loan is approved. Until that condition is met, the ownership does not yet pass to the buyer. Understanding the distinction is important, especially when determining the moment the legal ownership and lease are transferred. Let us now move on to the requisites concerning the object or thing of the contract of sale, as governed by the Article 1459 of the Civil Code. From this provision, we can identify two primary requisites. The object must be lawful or illicit, and the seller must have the right to transfer ownership upon delivery. For the object to be valid under contract of sale, the following conditions must be met. It must be determinate, meaning the object must be clearly identified or at least can be clearly identified later. Second, it must be lawful. The thing being sold must not be illegal. You can't sell something that's banned by law, like illegal drugs or stolen goods. Third, it must be possible. The object has to be something that can actually exist or be delivered. For example, selling the moon is not valid because it's not something anyone can legally or physically sell. Rights can also be sold, not just physical objects. If a person has a legal right, like the right to use a property, a usufruct, they can sell that right too. However, services or obligations to do, such as performing work, cannot be the object of a contract of sale. These are governed by the contracts for services, not by sale. For a contract of sale to be valid, the object being sold must be licit, meaning it must be lawful. If the thing being sold is illegal, then the entire contract is considered void, as if it never existed. Now, there are two ways an object can be illicit. Illicit per se or illegal by nature. This means that the object is always illegal no matter the situation. It's illegal in itself. For example, prohibited drugs or stolen property. These are the things that the law absolutely prohibits. You can sell or buy them legally under any circumstances, so any sale involving them is automatically void. The second one is illicit per accidents. It is made illegal by law in a specific situation. In this case, the object might not be illegal on its own, but it becomes illegal because of certain circumstances or legal restrictions. For example, selling land to foreigners is generally not allowed under Philippine Constitution. Land is not illegal per se, but selling it to someone who is prohibited by law, like a foreign national, makes the sale illegal. The seller must also have the right to transfer ownership at the time of delivery. This requirement reflects the Latin principle, nemo dat quod non habet. One cannot give what one does not have. It is important to note that the seller does not need to be the owner at the time the contract is perfected. It is sufficient that the seller acquires ownership by the time the item is actually delivered. The law allows the sale of future goods, items that do not yet exist at the time of the sale. This is valid under the Civil Code, unlike the notions of future property, which are generally not allowed under Article 751. Furthermore, even if a person is not the owner of the thing, if they possess a right over it, they may sell that right. For example, a usufructuary, who has the right to use and enjoy the property, may validly sell their usufructuary rights to another party. In a contract of sale, the thing being sold must be determinate, meaning it should be clearly identified or can be identified without making a new agreement. In simple terms, a determinate object is specifically identified, like say my blue iPhone 13, or physically set apart from others, like the second car in the garage. This is important in a contract of sale because we need to know what exactly is being sold. But the object doesn't have to be fully detailed at the time the contract is signed, as long as both parties understand which thing is being sold and it can be identified later on without making a new deal. When a sale involves a determinate object, that's the specific item you're getting. If that exact thing is lost or destroyed, there may be no replacement. But if the item is generic, like a sack of rice, it's not considered lost because it can be easily replaced. This follows the legal principle, genus nunquam perit, or generic things do not perish. Article 1461 of the Civil Code deals with the sale of things that do not yet exist, but are expected to exist in the future, also called as things with potential existence. Under the law, you can sell something that doesn't exist yet, as long as it is possible for it to exist. The contract becomes effective only if the thing comes into existence. But if there's no chance at all, like selling something impossible, the sale is void. There are two ways the law treats these situations. Emsores parate. This is when we sell something expected to exist, like a farmer selling his upcoming harvest. If the expected thing doesn't appear in emsores parate, the sale fails, because you can't sell what didn't exist. In emsores pay, this is when you sell the hope itself, like paying for the chance to win a prize in a lottery. Even if you don't win, the sale stands because what you bought was the chance itself, and you agreed to take the risk. By default, the law assumes you're entering into a sale an expected thing, not just hope. The court will protect the buyer unless the contract clearly shows that the buyer agreed to take the risk. Now, if there's absolutely no chance that the thing will come into existence, the sale is void. This is called the vain hope or expectancy. A good example is trying to sell a lottery ticket that has already been lost. There's no real chance left. In this part of the law, Article 1462 tells us what kinds of goods can be sold under contract of sale. The law allows both existing goods and future goods to be the object of the contract. First, existing goods are those that the seller already has. This is the most common and straightforward kind of sale. When I sell you something I already own or physically have. Example of this are second-hand laptop, furniture that already in stock, and a car currently in the seller's garage. Next, we have future goods. These don't exist or aren't old yet, but the seller promises to get them, produce them, or acquire them in the future. This can include making new products, harvesting crops, or even acquiring something later on, like buying and then reselling a vehicle. The law also allows sales that depend on a contingency, meaning the seller will only acquire the goods if a certain event happens. This is still allowed, but it carries some risk since the sale depends on something uncertain.
Article 1463. The sole owner of a thing may sell an undivided interest therein. It simply means that if you own something entirely by yourself, you have the right to sell a share of that ownership to someone else, while still keeping a share for yourself. Let's take an example. Maria is the sole owner of a piece of land. She can sell a half interest in that land to her friend Juan. Now, Maria and Juan are co-owners of the land. Okay, let's now move on to the Article 1464. This article explains that you can sell a specific quantity like a number, weigh, or measure from a larger mixed collection of identical items or fungible goods. What is fungible goods? When we say fungible goods, it means interchangeable, even if you don't know the exact total amount in that collection. The buyer then becomes a co-owner of the whole collection based on the proportion of what they bought. Even if the collection turns out to be smaller than what was sold, the buyer owns all of it, and the seller needs to provide the missing amount from the similar goods unless they agreed otherwise. For example, a farmer has a large sack of rice. He sells 50 kilos of rice to a buyer, even though he hasn't weighed the entire sack yet. The buyer now owns a share of the rice in the sack equivalent to 50 kilos out of the total weight. If this sack only contains 40 kilos, the buyer owns all 40 kilos and the farmer would usually have to provide the extra 10 kilos from his other rice. Let's move forward to Article 1465. Things subject to a resolutory condition may be the object of the contract of sale, like what we've encountered to the law of obligation, the resolutory condition. So meaning, you can sell something even if the ownership might end in the future due to a specific condition being met. The sale is valid, but the buyer knows their ownership could be terminated once if that condition occurs. Let's take an example. Dumbledore selling Hogwarts School to Harry Potter with the condition that Dumbledore can buy it back or repurchase it in 10 years is a subject to a resolutory condition. Harry becomes the owner, but this ownership is conditional on Dumbledore not repurchasing it within those 10 years. Even when Harry sells it to Voldemort, Voldemort's ownership is also subject to the same condition. If 10 years pass and Dumbledore doesn't repurchase it back, then Voldemort becomes the absolute owner. Article 1466. In other words, when a contract has features of both direct sale and an agency to sell, like a consignment, you need to look at the main parts of the whole agreement to decide if it is truly a sale or just an agency arrangement. For example, if a farmer sells carrots to a carrot vendor, it's direct sale. The vendor owns the carrots and can do whatever they want with them. However, if the farmer gives carrots to the vendor and it instructs them to deliver and sell those specific carrots in Bulacan on the farmer's behalf, then the vendor is acting as the farmer's agent. In this agency to sell, like consignment, the vendor is responsible for delivering and selling as instructed by the farmer or the consignor. And the vendor, the consignee, doesn't own the carrots outright until they are sold to a third party. The key difference is whether ownership is immediately transferred or sale, or if the person is just acting on behalf of the original owner to facilitate a sale, which is agency to sell.
Now, let's talk about Article 1468 on the distinction between a contract of sale and a contract of barter in a concise way. Imagine you're making a deal. Sometimes you're paying purely with money, and that's clear cut a sale. Other times you're swapping one item for another item, and that's what we call barter. But what happens when it gets mixed? What if you offer both cash and an item in exchange for something else? That's where Article 1468 steps in. This article tells us that the first and foremost, we look at the manifest intention of the parties. What did you and the other person intended that transaction to be? Did you both see it primarily as a purchase with the item just a part of the payment? Or did it feel more like an exchange of goods with some money involved to even things out? If that intention isn't crystal clear, then the law provides a practical rule. We compare the value of the thing you're offering to the amount of money involved. If the value of the item is more than the money, it leans towards being a barter. Think of it as an item being the main part of the deal. Now, let's talk about Article 1469 of the Civil Code. Article 1469 clarifies what certain actually means. It doesn't always mean spelling out a precise peso amount right then and there. The law recognizes a few valid ways the price can be considered certain. Firstly, the most straightforward way is if the parties explicitly agreed on a specific monetary value. Example, you say, I'll sell you this phone for 10,000 pesos, and the other person says, deal. That's a certain price. But it can also be certain if it's determined with reference to another thing certain. Just imagine agreeing to buy a gold at the prevailing market price on a specific date. The market price on that date is the other thing certain, making the final price determinable and therefore certain. Usually, Article 1469 also allows the determination of the price to be left to the judgment of a specific third person or persons. You and the seller might agree that a professional appraiser will assess the value of an antique, and that appraisal will be the selling price. This is perfectly valid. However, there's a catch. What happens if the designated third person is unable or unwilling to set the price? In that case, the law says that the contract becomes inefficacious, meaning it has no legal effect unless the buyer and seller get together and agree on a price themselves. Furthermore, the law anticipates potential issues with the third party's valuation. If the third person acts in a bad faith or makes a clearly mistake in setting the price, the court can step in and fix a fair price. Finally, Article 1469 addresses situation where the seller or the buyer prevents the third person from setting the price. In such case, the party who is in at fault has legal options. They can choose to either cancel the contract or demand that it will be fulfilled, and in either scenario, they can also claim damages from the party who caused the problem. If they choose fulfillment, the court will ultimately determine the price. So in essence, Article 1469 ensures that while the price doesn't always have to be fixed at the moment of agreement, there must be a clear and agreed upon way to determine it. This prevents ambiguity and protects the rights of both buyers and sellers in a contract of sale. Now, let's talk about Article 1470 of the Civil Code. Article establishes the general principle that gross inadequacy of price in itself does not invalidate a contract of sale. This is rooted in the understanding that parties are generally free to enter into agreements based on their own assessment of value, even if that value appears significantly low to an objective observer. The law presumes that individuals possesses the capacity to exercise independent judgment in their transactions. However, Article 1470 wisely provides for exceptions to this general rule. The first exception arises when the grossly inadequate price serves as an indicator of defect in consent. If the extremely low price suggests that the presence of fraud, mistakes, or undue influence exerted upon the parties, then the contract may be subject to annulment. In such cases, it is not inadequacy of the price itself that invalidates the contract, but rather the violated consent arising from these external factors. Article 1471 stated that if the price is simulated, the sale is void, but the act may be shown to have been in reality a donation or some other act or contract. But what exactly does a simulated price mean? It refers to a situation where the price stated in the contract is not the true intention of the parties. It is a false or fictitious price, and for an instance, the seller might declare a price, but both parties secretly agree that no money will actually be exchanged. The legal consequence of simulated price is clear: the sale itself is void. The law recognizes that a genuine contract of sale requires a real and intended price, and if the stated price is merely in a facade, lacking the true intention of the parties to exchange value, then the essential element of consideration is absent, rendering the sale without legal effect. However, Article 1471 offers a crucial caveat. It allows for the possibility that the underlying transaction, despite the simulated price, may actually be another valid contract. Specifically, the law says that the act may be shown to have been, in reality, a donation. Now, let's talk about Article 1472. Article 1472 keeps things practical when it comes to pricing certain goods. Think about stocks, grains, or liquids, which is the things with fluctuating values. This article says that their price is considered certain even if it's not a fixed peso amount right now. It is certain if the price is tied to what it will be on a specific future date, or what it's currently trading for in a particular market or exchange. You can even agree on a price that's a specific amount above or below that future or market price, as long as that additional amount is clear. And essentially, Article 1472 provides flexibility, allowing prices to be determined by reliable external references, ensuring clarity and avoiding future disputes in sales of varied commodities. However, Article 1473 provides a significant exception to this rule. It states that if the price fixed by one of the parties is subsequently accepted by the other, the sale is perfected. In this scenario, even though the price originated from one side, the other party's voluntary and equivocal acceptance signifies their consent. At that point, a true meeting of minds on the price occurs, satisfying the essential requirements for a valid and binding contract of sale. Therefore, while arbitrarily setting the price is prohibited as it undermines mutual consent. The law recognizes the validity of a sale when a price proposed by one party is willingly and knowingly agreed upon by others. This highlights the importance of acceptance in finalizing these key aspects of sales agreement.
Article 1474, where the price cannot be determined in accordance with the preceding articles or in any other manner, the contract is inefficacious. However, if the thing or any part thereof has been delivered and appropriated by the buyer, he must pay a reasonable price for it. What is a reasonable price is a question of fact dependent on the circumstances of each particular cases. And when there's a failure in determining the price, when the contract is executory, then the contract ceases to exist. There's no obligation for the buyer to pay and for the seller to deliver goods since the contract has no effect. But when the delivery has been made, then the buyer must pay a reasonable price for it. For the concept of reasonable price, this is the price that both parties must mutually agree upon with considerations of market conditions and other factors. And for the determination of fair market value, this is crucial for ensuring the fair transaction of both parties. And this is the price of a property when it is exposed on the public market with a knowledgeable and willing buyer and willing seller with no force or compulsion to enter the transaction. Article 1475, the contract of sale is perfected at the moment there is a meeting of minds upon the thing which is the object of the contract and upon the price. From that moment, the parties may reciprocally demand performance subject to the provisions of law governing the form of contracts. This article defines that a contract is perfected when there is a meeting of minds between both parties, and they can legally demand performance from each other about the obligation. And for the perfection of sale, the contract is perfected at the moment there is a meeting of minds between both parties, and this is not just an agreement but a legally binding contract about the terms and conditions of their obligations. Conduct of the parties, these are the actions and behaviors of the buyer and seller during the formation, performance, and termination of the contract. Transfer of ownership, the ownership is not transferred until the delivery of the thing, but the parties may stipulate that the ownership is retained by the seller until the buyer has fully paid the price. Next is the form of contracts. Generally, in law of sales, there is no specific formalities needed, so it can be oral or in written. But in some cases, it requires certain formalities for its enforceability. And consent reluctantly given, this is the consent that is not given freely or voluntarily, and it can invalidate the contract. Notarized deed of sale states receipts of price. This is significant because this serves as a formal acknowledgement of the payment that it is received and valid. Applicant's qualification to buy still subject to investigation, although this embodies all the essential elements of the contract of sale. An investigation is still needed to ensure the validity and legality of the transaction. Chattel mortgage of a car by mortgager buyer prior to transfer title to his name. The buyer can use this as a collateral loan even before the transfer of the title to his name, and this is valid, especially if the buyer has taken possession over the vehicle and the mortgage is properly recorded. Non-fulfillment by one party by his obligation. If one of the parties did not comply their obligations, then the injured party may demand for rescission with payment of damages. When definite agreement on manner of payment essential, this is important for the contract to be perfected, since a contract is binding and valid once there is a meeting upon the parties about the payment of the price. And effect of failure to pay price, this doesn't automatically invalidate the contract, but it gives specific remedies to the seller. He may either unsue for the unpaid balance or demand for rescission. And the right of owner to fix his own price. The owner of the thing may quote his own price, reasonable or unreasonable, and it depends on the buyer to either accept or reject it. Article 1476, in the case of sale by auction, an auction is a public sale where potential buyers compete of purchasing an item by placing their bids, and the item is sold to the highest bidder. This article addresses the sale by auction, governing specific rules for its perfection. Rules governing auction of sales. First, sales of separate lots or separate sales, meaning that each lot offered for sale in an auction is treated as separate contract. So if you bid multiple lots, then you are entering individual agreements. Sale perfected with the fall of the hammer. The fall of the hammer is usually designed to signify the end of bidding and the acceptance of the highest bidder. And the contract is perfected, and it is legally binding once the auctioneer announced the sale's completion. Right of seller to bid in an auction. The right of seller to bid is valid provided that such right was reserved, and the right to bid by the seller is not prohibited by the law or any stipulation. Contract not to bid. This is an agreement between both parties not to participate in the bidding process. And advertisement for bidders. This is a simple proposal or simple invitations to make proposals, and the advertiser is not bound to accept the highest or lowest bid unless the contrary appears. Right of owner to prescribe terms of public auction. This is generally the right of the owner to prescribe the terms in the price, venue, and terms of payment. And he may impose if the payment must be in cash or installments. And of course, the owner must comply with the rules and regulations. Article 1477, the ownership of the thing sold shall be transferred to the vendee upon the actual or constructive delivery thereof. This means that the buyer becomes the owner when the thing is placed to their control or possession, either physically or through legal means like transfer of title. Article 1478, the parties may stipulate that the ownership shall not pass to the purchaser until he has fully paid the price. The ownership of the thing transferred by delivery. The delivery is essential in a contract of sale, and there's a real right after the delivery of it. Exceptions to the rule. First, contrary stipulation. The ownership is transferred upon the delivery and not by mere payment, but the parties may stipulate that the ownership is retained by the seller until the purchaser has fully paid the price. Contract to sell. Here, the ownership is retained by the seller until he has fully received the payment, and such payment is a positive suspensive condition, for failure is not a breach or casual or serious, but simply an event that prevents the obligation of the vendor to convey title from acquiring binding force. And contract of insurance, a perfection of sale, even without delivery, vests in the vendee an equitable title, an existing interest over the goods sufficient to be the subject of insurance, and the contract of insurance is not valid and binding until the premium is paid.
Article 1479. A promise to buy or to sell a determinate thing for a price certain is reciprocally demandable. An accepted unilateral promise to buy or to sell a determinate thing for a price certain is binding upon the promisee if the promise is supported by a consideration distinct from the price. A consideration distinct from the price is also called an option. An option is a price different from the principal price, or a separate payment in exchange for the promise to buy or to sell. In this article, there are three kinds of promise. Number one is the accepted unilateral promise to sell, where the seller gives the promise and the buyer accepts the promise and gives consideration. Number two is the accepted unilateral promise to buy, where the buyer gives the promise and the seller accepts the promise and gives consideration. Number three is the bilateral promise to buy or sell reciprocally accepted. It is a mutual and immediately binding and reciprocally demandable, where either party can compel the other to perform. Meaning of an option. An option is a privilege existing in one person to which he paid a consideration that gives him the right to sell or buy. That consideration gives him the right to buy or sell in the agreed time and is demandable. Effect of unaccepted unilateral promise. A promise that is not accepted is not binding and is not demandable and has no legal effect. Article 1180. Any injury or benefit to the thing sold after the contract has been made to the time of the delivery. This rule should apply to the sale of fungible thing or the indeterminate thing made independently and for a single or without a consideration to the weight, number, and measure. In fungible things sold according to the weight, number, and measures, the buyer bears no risk until it has been measured, counted, and delivered, unless the buyer caused the delay. It also mentioned a Latin word which is the resperit domino. This means that the thing is lost to its owner, which means that if the thing is lost or damaged, then the risk falls on the owner. There are 4 rules on risk of loss or deterioration. One is if the thing is lost before the perfection, the seller bears the risk because the ownership is still on the seller. Number 2, if the thing is lost at the time of perfection, meaning that the ownership is still on the seller, so the seller bears the risk. Number 3, if the thing is lost after the perfection but before its delivery. This is an exception to the rules of resperit domino because this falls on the Article 1165 and 1162, which means that if the thing is lost without the fault or negligence of the seller, then the obligation is extinguished. Number 4, if the thing is lost after the delivery, the buyer bears the risk since the buyer is already the owner of the goods. In the sale of goods, by description or by sample or by both, the contract may be rescinded if the book does not correspond or is not the same as the description or as the sample. It is also stated that the buyer should have the opportunity to see if the both does correspond to the description or the sample or by both. The rules on sale. Number 1 is sale by description. In sale by description, the buyer has not seen the goods and only relies on the description. So, if the book does not correspond to the description, then the buyer can rescind the contract. Number 2, sale by sample. In sale by sample, the buyer relies on the sample. So, if the book is not the same kind, character, or quality, then the buyer can rescind the contract. Number 3, sale by both description and sample. The book should be the same as the description and the sample, and not only conforms to one. Article 1482. When earnest money is given in a contract of sale, it should be considered as part of the price and as a proof of the perfection of the contract. Earnest money. Earnest money is the money given by the buyer to the seller to bind the contract. It is also considered as a partial payment for the thing due, or what we call down payment. It is a proof that both parties agreed and perfected the contract. There is also an instance that the contract is not perfected even if earnest money is given. This is due to the loss of one or more elements of the contract, which is the consent, object, and cause. We have discussed before the option and the earnest. Whereas not to be confused, we will talk about the difference of both. Number 1, earnest money is part of the purchase price, while option money is a distinct consideration and is not part of the purchase price. Number 2, earnest money is given after the perfection of the contract, while option money is given before the perfection. Number 3, earnest money bounds the buyer to pay the balance, while option money does not require the buyer to buy, but only bounds the other party to not sell to other in a given time. For last, it is said that earnest money can become an option money if both party agrees. Article 1483. Subject to the provision of a statute of frauds and any other statute, a contract of sale may be in writing, orally, or partly writing and partly orally, or inferred from the conduct of the other parties. Form of contract of sale. It refers to the manner in which a contract will be made, executed, or manifested. A contract may be in any form to be valid if the essential requisite or elements is present. And a forms means if it's in writing or orally or partly writing and partly orally, or it can be inferred from the conduct of the other party. We have discussed before the validity of a contract. This time we will talk about the enforceability. In order for a contract to be enforceable, where form is required in order that a contract may be enforceable. According to a statute of frauds, there are cases wherein the agreement or contract must be in writing of the party or his agent to be enforceable. According to a statute of frauds, a contract may be in writing if A. The sale of personal property not less than 500. Personal property means like washing machine, TV, refrigerator. B. A sale of real property or an interest therein. A real property means a house, land, building, or condominium. C. A sale of property not within 1 year, regardless of the property or the price. For the sale of real property or an interest therein through an agent, the authority of an agent must be in writing, otherwise it will be void. As in the slide number 1, if the authority is not in writing, it is void. In 2A, if entered orally, it is unenforceable. In 2B means it is in writing but not notarized. Since it is in writing, it should still be valid. In 2C, if in writing and notarized, it is valid. If the sale has been made for the real property to be exclusively for the buyer and for the seller to not be able to sell the property again to other buyer, they must register it on the registry of deed where the property is.
Article 1484 applies to the sale of personal property payable by installment, not by a lump sum or straight-term payment. The vendor is granted 3 alternative remedies. The first option is to demand exact fulfillment of the obligation, requiring the vendee to pay for the remaining unpaid balance as originally agreed. The second option is to cancel the sale if the vendee fails to pay 2 or more installments. The third option is to foreclose the chattel mortgage if one has been constituted to secure payment of the installments and fails to pay 2 or more installments. However, if the vendor chooses this remedy, they may no longer recover the unpaid balance from the vendee. The vendor is granted 3 alternative remedies, meaning the exercise of one remedy waives the others. So that is the nature of these remedies. Next is rights of vendor to recover the unpaid balance of purchase price. The first remedy is specific performance, where the vendor can ask the vendee to pay the remaining balance as agreed. This means the vendor can still recover the unpaid amount from the vendee. The second remedy is cancellation of the sale. The vendor may choose to cancel or rescind the contract if the vendee fails to pay 2 or more installments. In this case, the vendee may ask for the return of the payments already made, unless there is a clear agreement in the contract that allows the vendor to keep those payments. This kind of forfeiture is allowed as long as it favors the vendor and is not unfair. The third remedy is foreclosure of the chattel mortgage. This applies when a mortgage was used to secure the installment payments. If the vendor chooses this option, they can take back the item, though foreclosure, but can no longer collect the remaining unpaid balance from the vendor. Article 1485. When the lessee takes possession of and uses the property, lease contracts with an option to buy are often, in reality, installment sales of personal property. Although they may be labeled as lease agreements, the nature of the contract is usually sale on installments. The law looks at the substance, not just the form. This approach prevents sellers from disguising installment sales as lease contracts with an option to buy, in order to avoid the protective rule under Article 1484 of the Civil Code. Article 1484 ensures that buyers of personal property on installments are not unfairly treated. Article 1486. The parties may agree in a contract that any rents or installment payments already made will not be refunded, even if the agreement is later cancelled or terminated. This kind of condition is generally valid as long as it is fair and not one-sided. However, if there is a disagreement, the court has the power to step in and look all the facts. If the court finds the keeping all the money or unfair to the one of the parties, it can decide that some or all of the money should be returned. This goal is to make sure that no one takes advantage of the other and both sides are treated justly under the law. Article 1487. The seller is responsible for paying the costs related to finalizing and registering the sale. However, the buyer and seller may agree that the buyer will cover those expenses instead. Once ownership is officially transferred to the buyer will then be responsible for paying any taxes and other related fees. If it turns out that the seller failed to reveal any other expenses or problems with the title, and this causes extra costs, the seller may have to pay for those additional expenses since it was their fault. Article 1488. Expropriation is the process where the government takes private property for public use. This process is governed by a special law, Rule 67 of the Rules of Court. It can only be carried out by a proper and authorized government authority. It is only allowed if it is for a public use or valid use for public purposes, and if the property owner is paid just and fair compensation.